Honourable members, let me be absolutely clear. The standing orders and the procedure as set up in this chamber is there for a reason. They are to be followed. At this point, I will just draw members' attention to Standing Order 52.2 and Standing Order 53 in its entirety. Let me just say that as much as it's the right of every member to raise on a point of order, there is a way to do so, and that must be followed. Anything outside of that is going to lead to chaos. Let this be the last time it happens. Attorney General.
Thank you, Mr. Vice President. Mr. Vice President, I was dealing with responses to the submissions of honourable senators, and I have made a few submissions so far. Permit me to continue with what I was saying, which is what this bill is and what this bill is not. Mr. Vice President, in dealing with the history of this legislation, it is important to note that in December 2015, when this law came into effect, it was passed on the 3rd of December 2010, forgive me. On the 17th of December 2010, there were certain amendments which followed on December 20th, 2010. So there were 3 rounds of consideration in 2010. This law brought into effect, Mr. Vice President, the ability on a statutory regime basis to control the interception of communication. Now, Mr. Vice President, it was said, and honourable members asked a question, opposition members asked a question about, well, rather, they made an allegation that you cannot have an illegal act permit a lawful thing. And they were saying, if a cell phone is deemed to be a prohibited article under the Prisons Act, that possession of a cell phone is an illegal thing, and that intercepting the illegal thing is in and of itself something which is not permissible. That, Mr. Vice President, is entirely the opposite of the law of the Republic of Trinidad and Tobago. I wish to put on record that it is trike law coming out of the case of R.V. Sang, that is 1980 Appeal Cases 402, that the decision of the courts put in this, that in the absence of statutory provision to the contrary, irrelevant to the admissibility of evidence is the manner in which it was obtained. So effectively, it matters not how you got evidence, whether evidence was obtained illegally even. Evidence as a matter of law is a matter for the judge to consider in the context of admissibility. So the submissions coming from honourable senators opposite are in fact flying in the face of settled law in this jurisdiction and throughout the Commonwealth. Mr. Vice President, it is material to note that the interception of communication right now is done in 2 ways. First of all, interception of communication in the context of the law is only to be an offence if you are intercepting communication over a telecommunications network. Let me make this clear. Intercepting communication via listening, referred to as eavesdropping, bugging or recording, that is not the concept captured under the Interception of Communications Act. Let me repeat that. The Interception of Communications Act only makes it unlawful to intercept communication which is going over a telecommunications network. It is important to bear that in mind because the law, if you have a warrant to intercept in Section 8 of the Parent Act, allows you to intercept telecommunications over the network. And if you go on the basis of a Section 6(2)B intercept that is unwarranted, you can intercept anything that is over a telecommunications network. And therefore, to listen to Senator Mark and the entire opposition bench say that this law is doing something, this bill is doing something which is draconian, is entirely and most respectfully nonsensical, because the existing law in section 6.2b allows everyone to be intercepted. Media, personalities, politicians, anyone. So how could it be that Senator Mark's submission could find any favor, Senator Hussein's submission, Senator Amin's submission, for them to say respectfully, these honorable senators, that this law is exposing the media to some draconian position, this law will intercept and condemn the rights of freedom of the press, is a nonsense to make that submission, Mr. Vice President. And I therefore answer Senator Richards' concern as to the protection of the media to say the media in this particular existing law is already intercepted under section 6.2b. It can be done for national security purposes, for breaches of the Act, etc. What we are doing today, honorable senators, we are making the existing law constitutionally stronger. Let me explain what I mean by that. The submission in the bill that is most relevant to independent senators' minds here today, because the opposition has said they're not supporting, so I'm speaking respectfully to the independent bench. What is critical in this bill is treating with the admissibility of evidence. Right now, the existing law can potentially be challenged as being unconstitutional. What do I mean by that? The potential challenge to constitutionality comes from an ouster of the court's jurisdiction. When we deal with the admissibility of evidence in section 17 of the existing law, section 17 of the existing law tells us in mandatory language that both for section 17 and for section 19, the law actually says that the evidence shall be admissible. The law actually also says that you cannot get, mandatorily cannot get, the sensitive information. Let me break this down. The existing law, section 17, section 19, does not allow a court to consider whether the evidence ought to be admitted or not. It just says to the court, you, Mr. Judge, you accused before the court, you have no right to actually consider whether this evidence can be admitted or not. You must admit it. That is dangerous, honorable senators. So what this government comes to do today, it does not come to intrude upon the rights of the media. That was done in 2010. In 2010, the UNC and the Parliament, with the PNM support and the independent support, we allowed the media to be intercepted in 2010. Fact, section 6.2b. What we have come now as a result of the learning and experience over 10 years of using this law is we're saying to the country, we need to preserve this law. We need to ensure that if there is a constitutional challenge to this law, that the law does not fall. Why? Because there are cases before the courts where this issue can arise, potentially. This is of general application. The last thing that we want to see happen in this country is to see people who are accused and who the state believes are guilty of serious offenses, from murder come down, walk free. Which one of us here would want to see the law collapse on ground of lacking constitutionality? And therefore, what we propose today in the amendments to section 17, the amendment to section 19 of the Act, the inclusion of a new section 17A, we introduce for the first time that a judge of the High Court shall be the only entity to consider admissibility of evidence in every circumstance. What could be offensive to the opposition, honorable senators? Why would an opposition claiming to be patriotic, as Senator Amin has, want to interrupt a move towards constitutionality?
We don't trust you.
And Mr. Vice President, that is why in the amendments that we have circulated, we are looking at this concept of preserving constitutionality for those matters that are considered in the whole of Section 6. Whether it was with express consent that you were intercepted, whether it was with implied consent, whether it was for national security, whether it was for the discovery of a crime, whether it is in a prison. We want to ensure that a judge is always the arbiter for the admissibility of evidence. Let's cut a finer point on that. We say that it would almost be impossible to admit intercepted evidence if we don't do this as a matter of law. Why? How can you admit evidence if you don't know who the maker of the evidence is, when it was produced, the state and condition of the device that was used, it was in good and proper order? You have to, if you want to admit evidence, other than by accepting the hearsay exceptions and rules, you have to lead the evidence into admissibility. And this is what this law does as a matter of law, honorable senators. I therefore ask you to ignore the submissions of the opposition bench, because, Mr. Vice President, it is in the face of constitutionality that we bring this amendment. Mr. Vice President, I'm not here to educate Senator Mark on the law. I'm here to make submissions on the law. Mr. Vice President, let's get to another point. There was a song and dance, hopping and screaming, bawling and wailing, gnashing of teeth over the concept of stored communication and stored data. So, what does this bill propose? This bill proposes a number of things in relation to that. First of all, we acknowledge that the existing laws of the Republic of Trinidad and Tobago allow for access via the courts of Trinidad and Tobago to stored communication and to stored data. Let me explain that. A cell phone that has information on it. The existing law of Trinidad and Tobago, the Preliminary Inquiries Act, Section 5, the Proceeds of Crime Act, Section 32 and Section 33, and in fact the entire civil law regime, Norwich Pharmacal Orders, Anton Pillar Orders, the general powers and provisions under Section 242 and Section 245 of the Companies Act, all of them permit a court to order data to be accessed, historic data. Today, the opposition arrives to rewrite the laws of the Republic of Trinidad and Tobago to say that that does not happen. That is not true. This is trite law. And I am astounded that Senator Hussain and Senator Sobers and Senator Sturge, all three of whom are members of the Bar of Trinidad and Tobago, would not have the intellectual courage to say what I just said. Worse yet, to allow Senator Mark to go on the wild frolic intellectually that he ventured upon to say that this is draconian. So let me make it clear. Stored communication, stored data, Section 5 of the Preliminary Inquiries Act, Section 5 of the Administration of Justice Preliminary Inquiries Act, Section 32 of the Proceeds of Crime Act, Section 33 of the Proceeds of Crime Act, the general law of Norwich Pharmacals as it has been applied in civil cases, and in fact many other provisions expressed in Anton Pillar, etc., all permit that. That is why in Section 4, Clause 4 of the bill, we insert a savings provision to keep the method of obtaining a magistrate's warrant, because a magistrate's warrant is under the Proceeds of Crime Act and the Preliminary Inquiries Act and the Administration of Justice Preliminary Indictable Proceedings Act. We must preserve it. Why? Because the rule of law is something called implied repeal. If a government comes forward with a law today and does something that commits us to go on the left hand only, it is understood in law that you may have stopped the method of going right. I'm breaking it down simply, and that's called implied repeal. A subsequent law can impliedly repeal an existing law if it is not expressly preserved. And therefore today, out of an abundance of caution as a responsible government and as a responsible Attorney General, Clause 4 of the bill, in the amendments you'll see we are specifically saving the Proceeds of Crime Act, Section 32 and Section 33, the Indictable Proceedings Act, as we preserve Section 5. I've pointed out to the CPC's department that we need to add the Administration of Justice Indictable Proceedings Act, because that law is going to become law in its full form. It was already proclaimed when that unholy proclamation of Section 34 happened, so that law actually exists side by side. Let's deal with another point. There was a most unfortunate, if not intellectually ridiculous, submission made here this afternoon by Senator Sturge. Senator Sturge came to this Parliament and told this Parliament and told the country that we were going to broaden the application of this law to civil proceedings. For heaven's sake. Senator Sturge has had the benefit of the printed material that this government and country and taxpayers have paid for. It is in fact the legislation before us. And I want to confirm, Mr. Vice President, that this act only applies to the following: criminal proceedings, and it is in Clause 4 of the bill. Criminal proceedings. Proceedings under the Proceeds of Crime Act, Chapter 1127. Proceedings under the Extradition, Commonwealth and Foreign Territories Act, Chapter 1204. Stick a pin, that's criminal matters. Proceedings under the Anti-Terrorism Act, Chapter 1207. That is as close as you can get to very serious criminal matters, but there is the Section 22B civil proceedings for listings aspect there, so it's quasi-criminal in that regard. E, the proceedings under the Civil Asset and Management and Unexplained Wealth Act number 8 of 2019. That, as you are well aware, is a law which we passed as a government, which allows you, if you are the subject of specified offenses listed under the Proceeds of Crime Act, in other words then criminal proceedings, to be caught under that legislation. So it is irresponsible and a downright untruth for Senator Sturge to say as bold-facedly as he did that this law is to broaden into the civil arena. That is not true, Mr. Vice President, and must be rejected. That is fear-mongering at its highest, Mr. Vice President. Mr. Vice President, the fact is that the issue of the special advocate has arisen. And in this government, opening the constitutionality and improving the constitutionality of the law, we are saying, do not oust the court's jurisdiction, make all matters of admissibility of evidence subject to the court's discretion, do not give a statutory automatic admissibility of evidence, go the due process route, the right to fair hearing route, improve the right to fair hearing. But when you come to sensitive information, and what is sensitive information? Sensitive information, as previously defined in Section 17 of the Act, the existing law, which we've now moved to the interpretation section, sensitive information is who was intercepting you, what circumstances they intercepted you with, who has the warrant for the interception. That sensitive information as a matter of national security ought to be very carefully and jealously guarded. But we accept, as we improve the constitutional parameters of this law, that it may be in the interest of justice for that information to be disclosed. It may very well be that a defendant is entitled to that information, but let a judge decide that. And in improving the constitutionality, we say if you are going to disclose the warrant, which will have that information, if you're going to disclose the workings of the interception of communication, let a special advocate in a special procedure deal with that. We didn't pluck this out of the sky. We pulled this from umpteen jurisdictions. We pulled it from the United Kingdom, from Canada, from the New Zealand experience, from the United States, from the European Union. We pulled this law of the use of special tribunals and special procedures so that a judge can consider what ought to be considered in the admissibility of evidence, putting safeguards. Now, it may very well be that one wishes to consider the introduction of special advocates coming a step away. In other words, then, let the regular attorney engage in that process. But as pointed out by one of the senators this afternoon, the criminal bar in Trinidad and Tobago is extremely small. That is why Senator Choate was on the ball in referencing clauses 23 and 24 of the bill. Let me explain what I mean by that. We anticipate that rules of the Supreme Court will have to be promulgated to define the special measures procedure. That is why we have put in the provisions for the Rules Committee, the Chief Justice and the several members, including the Attorney General, the Bar Association and the Law Association's representation, etc., to sit and draft the rules. That allows for a flexibility of approach. It allows the law to change from time to time. It is also why we included a new section for regulations to be made under the Act. And I can tell you now, the Attorney General's Office, the LRC, we have drafted the regulations already for the data storage, for the chain of custody, for the destruction pursuant to Section 20 of the Act. All of that has been drafted already. What was missing was the force of law. Because in the 2010 Act, the breach of regulations would only attract a $500 fine. Why? Section 63 of the Interpretation Act says if you are guilty of a breach of a regulation and the law is silent as to what that breach is, in terms of consequence, you're subjected to $500 fine. That's why you will see in the clause 24 before us.
I hate to interrupt when the Attorney General is in flight, although he does it to me from time to time. But in the sections that he spoke about, 17 and 19, I'd like his assistance, please. Because what I'm hearing him saying is that the court didn't have any discretion. And I'm seeing the court may exclude such disclosure written in 17 and also in 19. So perhaps if he can assist my understanding, I would be exceedingly grateful.
Sure. If I could just finish the point on the regulations first, and I'll come to that. So in clause 24, Mr. Vice President, where we insert a new position for regulations, we're amending Section 25. You'll see we're providing for a breach of the regulations to attract a criminal offense. That criminal offense in the amendments to Section 25 will then result in us having a summary offense exposure together with, and I just want to get this right, a fine of $250,000 as maximum upper limit and imprisonment for 2 years. So the regulations, which will deal with chain of custody, processes, procedures, who is entitled to hold, etc. We have that in regulations. We have an offense now for the first time of meaningful worth. But more particularly is we have set out in this law very careful safeguards as to when a judge ought to do certain things. Before I come to Senator Thompson-Nai's position, permit me to deal with the safeguards issue. In the safeguarding issue, I wish to point out that We are insistent in the new sections to be inserted around section 17, that's the new section 17A, and that springboards from section 17 and then flows to section 19. In section 17, we are saying, in this section and in section 19, we protect the warrant for the interception, the warrant for the interception of communication, the warrant for interception of stored data, the warrant for the interception of stored communications, the three categories. We then protect the details and identity. We say that a judge is mandated to consider, this is in the new 17(2)(c), a judge must consider, if he's going to make an order in 2A or 2B, that all of the circumstances are to be considered concerning the obtaining of the communications data, stored communication, whether the defendant was induced to say what he did, and any other relevant factors which would render what he said unreliable, and he shall consider in respect of such communications. And then we go through items A through E, whether you were induced or tricked into saying certain things, the integrity and recording was sound, the use of the recording device was proportionate to the gravity, etc. These come from the case law and statutory provisions of the United Kingdom. Contrary to what Senator Sobers submitted in his contribution, we are not really close to the RIPA legislation. We are in fact in a different regime. We are not mirrored to the Regulation of Investigatory Powers Act 2000 as it was amended in the United Kingdom. We are in fact much closer instead into the investigatory powers route. We're looking at the 2016 law, Investigatory Powers Act 2016. It is in that law that we treat with prisons intercept. Now, a very important point for honorable members to bear in mind, I pointed out previously interception of communications was only in the context of telecommunications network. This law, for the first time, treats with bugging, not over a telecoms network. Prior to this amendment, eavesdropping or bugging, which is not over a telecommunications network, is arguably outside the law and unregulated. We have introduced it in a very careful place. We've introduced it in a prison. And even though the European Court of Human Rights has recognized certain parameters of rights for prisoners under Article 8 of that convention that binds them, even though we have the right to private life recognized in Section 4 of our Constitution, it is a foregone conclusion, recognized internationally, that prisoners do not enjoy the same extent of protection of rights as do citizens who are not in prison. That is not to say that we have not captured that carefully in our law. We have introduced proportionate mechanisms. There must be a warning. You must be informed. There must be signs up to that effect. You must be provided with a room to speak to your attorney at law, which guarantees the protection of legal professional privilege. And what we say inside of this law is that for the first time we are saying that this law is to be regulated. That's why CCTV systems exist in prisons right now. They exist in public roads, they exist in buildings. You call a bank right now and you'll hear a recording on the phone saying this call may be monitored for quality and consistency concerns. They are monitoring you right now. They didn't bring a 3/5 majority law to do that. Why? Because they can. And I did not say that there is no right to private life. And no ex-Chief Justice had to correct me. There is no absolute right to private life. And that is recognized by the very Constitution that we have, where Section 13 of the Constitution allows you to abrogate Section 4 and Section 5 rights of the Constitution. So we have introduced very proportionate mechanisms. We have said that judges need to have regard to the whole of circumstances, but very importantly, is it 59 I end? But very importantly, we have preserved a critical piece of law, which is in the common law. Section 20, subsection 9 is being introduced, which is to allow the public immunity exceptions. We are saying for the first time, destroy all information that is not relevant immediately. If it's a warrant for stored communication, if it's a warrant for intercepted communication, if it's outside the parameters of what you need, destroy it. But we've said, if that information reveals the commission of an offense by somebody else, you cannot destroy it. A prosecutor can keep it and then argue why he must keep it under the parameters of public immunity interest. And that is a nuclear provision of balancing the rights inside of here. We've heard about the balancing of rights. Let me be very bold here. One could carefully argue that this law, in fact, if it is slightly modified, does not need a 3/5 majority. What do I mean by that? We certainly don't need a 3/5 majority to invite the court to consider the admissibility of evidence. We don't. We don't need a 3/5 majority to say that you can have interception under national security purposes. That's there already, section 6(2)(b). So I want to caution the opposition in the exuberance of their own inebriation that we can quite safely treat this law in different ways, but we have approached the Senate and approached the Parliament in a very careful way. We want to clothe this law with the maximum extent of constitutionality permitted. And honorable members need to be certain. You will recall there have been occasions when, because of the position adopted by the opposition, the government was compelled in making sure that we were not blacklisted by the FATF to strip off certain clauses that offended 3/5 rights and go with others. And that happened in the Income Tax Amendment Act when, Mr. Vice President, ask Senator Mark to behave. So we were extremely careful to understand the parameters that we are operating under. There is little to cause concern in this law. In this law, we are in fact improving the constitutionality. And I was dealing with the concept of balancing of rights. While Senator Mark is insistent upon protecting the rights of prisoners, and there are certain limited rights for prisoners, I accept, but that seems to be Senator Mark's goal. The government of the Republic of Trinidad and Tobago is concerned about your primary right to the right to life in Section 4A of the Constitution. We are at war with criminality. And we must be careful as the legislature of this country to give a fighting chance to the Trinidad and Tobago Police Service, the courts of Trinidad and Tobago, in a fair and balanced process. And Mr. Vice President, we are adamant that the UNC will be exposed. When we look to the position of exposure in refusing to support the bail amendments, which this Senate passed without their support, it is the same on-point position here today. Because, Mr. Vice President, who in their right mind, wanting Trinidad and Tobago to be safe when all of us are exposed to crime, will say, go ahead and let criminals occupy the space of this country with impunity? Mr. Vice President, right now, the intercept evidence is available. I've heard the opposition members say with aplomb, put on the jammers. Mr. Vice President, the fact is that we have criminalized the taking in of prohibited articles, meaning telephones, in Act number 25 of 2019, the miscellaneous provisions where we amended the Prisoners Act. But it is also a fact that criminals masquerading as prisons officers to the detriment of their hard-working colleagues and the citizens of this country, in a betrayal to the Prisons Officers Association and the people of Trinidad and Tobago, they are taking phones into the prisons. Worse yet, they're taking legal phones, their own phones, into the prisons. So we could ban all the phones possible, but the Commissioner of Police has said to us, it is by far better from an intelligence perspective to use the interception as evidence in a court of law. I confess, as I've said openly in this Parliament, I received a telephone call from F12 in the Port of Spain maximum security end of it, telling me as Attorney General where grenades, guns, and ammunition was to be found in the prisons, and we found it. And Senator Sobers was decent enough, the Honourable Senator, to admit that he's aware of these circumstances, but Senator Mark, who sits on the bench with him, don't want to hear none of that. Prisoners' rights matter in this country. It didn't matter in 2010 when the law was being passed. Media rights matter in this country. It didn't matter in December 2010 when the entire media corps was subjected to Section 6(2)B, which allows everybody to intercept the media's communication. It didn't matter then. Two-faced arguments coming from Senator Mark and the opposition, Mr. Vice President. And therefore, I urge honourable senators to reject the distractions created this afternoon, this evening and tonight, and also on the occasion in February when we were last here, because this is a matter of writing the scales of constitutionality. This is a matter of writing the scales of justice. There are adequate safeguards in the law. We have incorporated the learning coming to us in the courts of Trinidad and Tobago over the last 10 years. We have incorporated the learning coming from the European Court of Human Rights, the courts coming out of the United States, the United Kingdom, New Zealand, Australia. It's good enough for the whole world to do what we propose today, but it's not good enough for the UNC. That is the definition of insanity, Mr. Vice President, if we accept the opposition's point of view. So, Mr. Vice President, no matter of bawling, crying, gnashing of teeth would allow me to be distracted. Senator Marks, histrionics, intellectually, will not distract the right-thinking people of this country into their position. No amount of taking home tea and deck chairs for the comfort of your wife in making sure, if a prisoner does that, Mr. Vice President.
As much as you're wrapping up, just be very careful about the line that you're going down.
Speaking about offences, Mr. Vice President, when we deal with offences of taking home public...
Continue.
Yes.
Okay.
So, Mr. Vice President, I think Senator Mark is uncomfortable, but I don't know why. Maybe he knows something else. Mr. Vice President, what I'd like to see is that I am certain of the constitutionality of the amendments that we're making. I believe that this law is for the best intention of the people of Trinidad and Tobago. It is for the peace, order, and good governance within the meaning of Section 53 of the Constitution, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be now read a second time. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Attorney General? Oh, no.
Mr. Vice President, in order to stand order 66(1), I beg to move that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508. Sorry, you didn't read the second?
Yes, didn't read it.
I apologize.
A bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508.
Now, Attorney General.
Mr. Vice President, in accordance with Standing Order 66(1), I beg to move that a bill entitled An Act to Amend the Interception of Communication Act, Chapter 1508, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay. Okay, honorable members, there are 26 clauses and a preamble in this bill. The Attorney General would have circulated earlier in the day amendments. Is everybody in receipt of those amendments? Yes? There was a second set, the one at 6 p.m., 3rd of March 2020, 6 p.m. revised. Top right-hand corner.
And Mr. Vice President, I could indicate that there's only, I introduced it in my winding up, but there's a small tweak to this which I can give orally as to two certain aspects of what has been circulated. So the draft that we're working with is that circulated at 6 p.m., which are the amendments to clause 4, etc.
You want to just indicate the particular clause in the amendment that you want to tweak, so when we get there we know?
Yes, sir. We're looking at clause 4. If you turn to the second page of clause 4. Honorable members, we're at the draft. I see Senator Dillon's hand up.
I have 2 copies of the
So we will
9:42 a.m. I don't have a 6:30.
I see.
I don't have a 6:30.
Also, can we have Senator Dillon when we furnished with a 6 p.m. copy of the amendments? Is everybody else in receipt of that amendment at 6 p.m.? There was one that circulated, Senator Mark, at 6 p.m. Can we have one for Senator Mark as well, too?
Senator Mark circulated one?
Though he didn't have the 6 p.m. one.
Oh, I see.
Right, AG, just in the meantime, so clause 4 will be tweaked?
Yes.
Just the clause, you don't have to go into the
Clause
actual
4,
tweaking.
subclause 4 on page 2, right? So there'll be a small amendment to subclause 4 on page 2.
On page 2.
Yeah? And then what we're proposing, Mr. Vice President, would be at the very last page where we're doing consequential amendments.
Okay.
Yeah? So at the very last page, we're going to, it'll be a new clause 28. It'll be a new clause 29. Right? So we're proposing a new clause 29, which will deal with a certain amendment to the Administration of Justice legislation.
All right. Okay. So let me just say, as we're about to start, as much as the debate itself would have generated a bit of contention, going through this committee stage in the interest of time, I would just remind everyone to operate with a little bit of discipline and tolerance so that we can engage in maximum production. Okay? Right.
Clauses 1 to 3.
Honourable Senators, the question is that clauses 1 to 3 stand part of the bill. Honourable Senators, the question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stands part of the bill.
Clause 4.
Honourable Senators, the question is that Clause 4, which has amendments, Clause 4 stand part of the bill.
Mr. Vice President, if I could indicate that Clause 4 is circulated, if you would indulge me in indicating where I propose that there is a further amendment, it is to be found in subclause 4.
Subclause 4.
So, in subclause 4, which is at page 2 of the circulated amendments, which starts off with the words, on the coming into force of this Act, the provisions of the Proceeds of Crime Act, and the Indictable Offences Preliminary Inquiry Act. Just after that word Act, Mr. Vice President, if we can insert reference to another piece of law, and that law to be inserted is the administration of justice, open brackets, indictable proceedings, Act number 20 of 2011. No, the brackets closes just after proceedings, so it'll be insert the administration of justice, open brackets, indictable proceedings, close brackets, Act number 20 of 2011. Yes, so that's just after the word Act. Pardon? I see. Mr. Vice President, I'm told that it's tidier, and forgive me, that we insert the reference to that Act after the Proceeds of Crime Act. So if you would just look at it, insert the very same thing I said just after Proceeds of Crime Act. And when you get to the position of allowing me to explain, I'll explain why. Okay?
Okay. You can go ahead and explain Clause 4.
Yes, please.
In your amended
So,
version.
honourable members, through you, Mr. Vice President, you will note that Clause 4 of the bill says, 4.1, this Act applies to. In effect, it was floating without a root, because we didn't amend a section in the parent Act. So, what we have here, up to subclause 2, we're repeating in the circulated amendments, but we're tying it now to insert into the Act a new 4A. It needs to be rooted into the parent Act. So what you see in the circulated amendments 4A1 and 4A2 is exactly as appears in the bill, except it's now rooted to a new 4A in the Act. So this Act will only apply to criminal proceedings, proceedings under POCA, proceedings under Extradition, Commonwealth and Foreign Territories Act, which are criminal proceedings themselves, proceedings under the Anti-Terrorism Act, and proceedings under the Civil Asset Recovery and Management and Unexplained Wealth Order Act. Then we go, subclause 2 stays the same. Subclause 3 is a very important position, and this says, as circulated for the avoidance of doubt, all those things which were obtained under Section 5 of the Preliminary Inquiries Act and Sections 32 and 33 of the POCA regime, that those things were lawfully done. Because we don't want the argument that there was an implied repeal. As a matter of fact, there have been umpteen warrants obtained over the last 10 years since the passage of this law. They have all been validly entered. We wanted to strictly preserve that position. In subclause 4, we're making it abundantly clear. This is now the implied repeal argument. We're making sure that we don't remove the existing law provision under Proceeds of Crime, under the PI Act. I remind honourable senators that we're in the process of moving to repeal the Preliminary Inquiries Act, and we'll be replacing it with the now fully amended Administration of Justice Preliminary Inquiries Act, Indictable Proceedings Act, forgive me, and therefore that Section 5 warrant needed to be preserved, hence the insertion of the language that I just suggested. Those are the reasons for the proposed amendment, Mr. Vice President.
Okay. Honourable members, I shall now put the question. If you follow along carefully, the question is that Clause 4 be amended as circulated and further amended at subclause 4 after the words Proceeds of Crime Act, insert comma, and the words the Administration of Justice, open bracket, Indictable Proceedings, close bracket, Act number 20 of 2011.
Vice Chair.
Senator Vera, you have a...
I don't think you need to put the number of the reference, because that would be done in the marginal note, and we should be consistent with the way it's done throughout.
Thank you for legislative drafting expertise.
I can take out number 20?
Yes, sir.
Okie dokie, I'll do it again.
My
Honourable members, the question is that Clause 4 be amended as circulated and further amended as follows at subclause 4 after the words Proceeds of Crime Act, insert comma, and the words the Administration of Justice, open brackets, Indictable Proceedings, close bracket, Act of 2011. Just Act?
yes.
Okay. Those in favor say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 4 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
Honourable Senators, the question is that Clause 5 stand part of the bill.
It's an amendment. There's an amendment circulated to Clause 5. Mr. Vice President, we just want out of a caution, insofar as stored communication can be in whole or in part, to insert those words. So in the definition of stored communication, after the word transmitted, to insert the words in whole or in part.
That's it?
Yes, sir.
Okay, if there's no further additions, Honourable Senators, the question is that Clause 5 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that Clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 5 as amended now stands part of the bill.
Clauses 6 to 8.
Honourable Senators, the question is that Clauses 6 to 8 stand part of the bill. Honourable Senators, the question is that Clauses 6 to 8 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 6 to 8 now stands part of the bill.
Clause 9.
Honourable Senators, the question is that Clause 9 now stand part of the bill. Attorney General.
Mr. Vice President, we're simply just adding the marginal note in. There are two schools of thought that you need to amend the marginal note by the Law Revision Committee or by this method. So just out of an abundance of caution, we're adopting this method.
Okay, if there are no extra additions, Honourable Senators, the question is that Clause 9 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that Clause 9 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 9 as amended now stands part of the bill.
Clauses 10 to 14.
Honourable Senators, the question is that Clauses 10 to 14 stand part of the bill. Senator Timal.
Through you, Chair, to the Attorney General, Clause 10, Section B1, the words "at their own cost." I had raised this in my contribution, the legality of imposition of such costs on the telecommunication service providers, AG.
Sure. I thank the Honourable Senator. There are two forms of legality for this. Number one is under the concession license, which is the licensing regime under the Telecommunications Authority. That's legislation. Licenses permit the imposition of costs, particularly when one is concerned with national security. So it isn't your right without restriction or without condition to operate in this jurisdiction. So there is, under the telecommunications regime, an absolute right of the state to deal with this. Number two, the cost has become an issue because the interception capability on the government's part has to be modified at great cost to integrate with the telecoms network. On the other hand, the telecoms network, if it were to just give you the information requested, is basically at no cost because they are at capacity already. So this is a mechanism at relatively little cost, if any at all, to allow for the provision of that which has been warranted and that which has been allowed, and it removes the need for massive expenditure on the part of the taxpayers to meet certain standards and integration. But the legality of it is purely under the TAT regime, the telecommunications regime.
Senator Timal. Good?
Yeah.
Okay, if there are no other submissions. Honourable Senators, the question is that clauses 10 to 14 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 10 to 14 now stands part of the bill.
Clause 15.
Honourable Senators, the question is that clause 15 stand part of the bill. Attorney General.
Mr. Vice President, at clause 15, the amendments as circulated are intended for us to capture the fact that there may be interception permitted in other laws. So, for instance, at present we have the Administration of Justice Indictable Proceedings Act. At present we have the Preliminary Inquiries Act. At present we have the Proceeds of Crime Act. Those are three known laws as at this point. What we're making sure is, firstly, in paragraph A, we insert the concept of any other written law. In paragraph B, where we are inserting an amendment to the new proposed subsection 2A, if honourable members look to that particular provision, 2A did not have the qualifying safeguard of "in the interest of justice." If you look at 2B, this is at page 17 of the bill, you will see that the words "in the interest of justice to so admit" are present. We wanted to make sure that the judge had an overriding discretion in both 2A and 2B in circumstances where it was even a foregone conclusion that consent was given. We still want to put in the safeguard of "in the interest of justice." So 2A refers to section 2C, D, E, F, or G. Those are all the circumstances in the existing law where you did not need to have consent or a judge consider the admissibility of evidence. A, because it was given by consent. B, it was express. C, it was implied. D, it was in the course of a private network where there was an express condition, etc. Those are all the circumstances in those particular subsections. We figure that it is by far a better safeguard to put the interest of justice and make 2A and 2B all subject to judicial discretion for admissibility of evidence. So we're giving the judge the final position. That's what B in 15 in the circulated amendments refers to. In paragraph C as circulated, we are tightening up what we call the Bailey conditions. So, Mr. Vice President, if you were to see at page 18 of the bill, 17 and 18 of the bill, in 2C where we have references to ensuring that the judge had to have in mind that the person wasn't tricked, induced, etc. These all come from a very famous case called Bailey. In the Bailey case, the judges had set out what were conditions to be included, but in our bill, we only speak to recording. We want to also include the position of interception, so that there are Bailey, B-A-I-L-E-Y is the case name. There are Bailey conditions of safeguards included for not only recordings, meaning buggings, but also for interceptions. And that interception includes all forms of interceptions. There are 3 species of interceptions: interception of communication over a telecoms network, interception of stored communications, and interception of stored data. In subparagraph D, we had inadvertently used the singular of communication data. It really is communications data as it is properly defined. That is the rationale for the proposed amendments. Those are the various grounds of rationale.
Mr. Chair, on page 2 of the revision amendments, you had new clause 12A. Will that be considered after?
Yes, so new clauses come at the end.
After. Okay,
I apologize for inserting it that way.
Senator Vera.
Thank you, Chair. CB, where you have in paragraph E, delete the word which. Shouldn't
Yes.
it also be which occurred? Because you'll now read, no recording of any conversation subject to legal professional privilege occurred in a place.
Yes, you're correct. Thank you again.
So which occur?
Hold on one moment. I'm being tugged by the CPC's department. Okay, so Mr. Vice President, just out of caution, if you'd permit me. So 2C says, in making a decision under these sections, the judge shall consider all circumstances, etc. Goes a little further down to say whether the defendant was induced, he did, which would render what he said unreliable, and he shall consider, in respect of the communications, that, if we get to E, no recordings of any conversation subject to legal professional privilege which occurred in a place specified by the minister under section 2B. So we're proposing the deletion of the word which. So if we read that, Chapeau, in making a decision, the judge shall consider, in respect of the communications, that no recording of any conversation subject to LPP occurred in a place specified by the minister under section B2. So we'll keep the word occurred. So it is correct.
Okay.
Thank you for the tell.
If there are no further submissions, I shall now put the question. Honorable Senators, the question is that clause 15 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 15 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 15 as amended now stands part of the bill.
Clauses 16 and 17.
Honorable Senators, the question is that clauses 16 and 17 stand part of the bill. Senator Dion Ryan, sir.
Thank you, Mr. Chair. Just a point of clarification for clause 16, subsection 2, 17A, subsection 2. In terms of the appointment of the special advocate, what level of familiarity with the existing case the special advocate usually have? And also, if the level of familiarity with the case is almost none, would there be a time duration that the special advocate would be allowed to become familiar with the case so that they can truly represent the accused in the closed proceedings?
Yes, sir. This question dives to the heart of the concept of fair trial and procedure, so I welcome the recommendation to consider this and to explain. First of all, I'd like to take the Honourable Senator to subsection 4, where we have a definition of the special advocate. Special advocate means an attorney at law appointed by the court to represent the interests of the accused or the defendant, as the case may be in closed proceedings, B, who acts in the interest of justice, and C, whose function it is to represent the interests of the accused or defendant, as the case may be, by making submissions to the court, adducing evidence, and cross-examining witnesses, making applications to the court, seeking directions from the court, and generally assisting the court. That is materially tied on to the clause 24. And clause 24, which inserts a new section 25A, allows for the Rules Committee of the Supreme Court, established by the Supreme Court of Judicature, to, subject to negative resolution, make rules to govern proceedings under the Act. It is intended that the rules of the Supreme Court will be expressed in the processes for the special measure and the special advocate. The special advocate will usually come into the matter in fresh form, in other words, then will be appointed, and then there will be a process via the rules for the special advocate to take instructions. Those instructions will be granular in nature. Fortunately, we have the rules in existence from many other jurisdictions which tell us what the special advocate does and the process by which the special advocate engages in taking instructions and representing the rights of the accused. It is at that point that the advocate goes into position and takes the interest of the accused before the court. This is not too far off the concept of supervising attorney who represents a court in ant and pillar orders. An ant and pillar order is a very draconian measure in the civil law remedy, which allows for the court to ex parte, without the other party who is being affected, to make an order allowing for seizure, search and seizure of anywhere, any place, all documents, etc. It's a very brutal process. The court appoints a supervising attorney, and that supervising attorney provides a report to the court, etc. So this is not uncommon to us in very draconian circumstances in the civil law. In fact, extremely draconian circumstances, and there's a lot of case law on it. So we intend that the rules of engagement for the special advocate will be granular in the rules of the Supreme Court so that this is properly exercised in the right interest.
Okay. Senator Sipasad. Senator Sipasad.
Mr. Attorney General, who pays this special advocate?
The state pays. Same way the state pays for judges, the state pays for the prosecutor, the state pays for the special advocate. The state will be paying for public defenders very shortly, in a matter of weeks. The state will be paying for public defenders who will represent the accused by way of appointment.
Okay.
Competent counsel as opposed to counsel of choice. If your counsel of choice is not available 1, 2, 3 times, the state will appoint an attorney for you as a public defender so that the state pays for your lawyer.
Okay. Thank you.
Senator Thompson-Aye.
Particular reason why court was downgraded from A to C, 4 places, it becomes common.
This is in the bill? I'm sorry, Senator, your microphone is a little away from you, so I didn't hear.
Yes,
clear.
it's in the bill.
Would you say that again, please?
4, are you not at section 16, 4? Page 22.
What I can say is that in the proofing of this, the capitalization and common will be dealt with. So the proof that comes from the CPC's department in the bill as amended will tidy up the inconsistencies between capital C and common C, which ought not to be there. So duly noted. Yeah?
Noted.
Thank you so much.
If there are no further submissions, Honourable Senators, the question is that clause 16 and 17 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 16 and 17 now stands part of the bill.
Clause 18.
Honourable Senators, the question is that clause 18 stand part of the bill.
There's a circulated amendment at page 6 of the bill for 18, 19, and 21.
Really?
Page 6 of the circulated amendments. In the rush to prepare this, Mr. Vice President, I want to apologize. We really should have put all the new clauses at the end. So I've a little bit buried, and I apologize for that. But I only got the chance to look at this on the floor.
Yes. Okay. Go ahead.
Yes, Mr. Vice President, the amendment proposed to clause 18 is really quite simple. We're going from communication data, which is not the proper defined term, to communications in the plural data, which is the correct term, and that's the circulated amendment to clause 18.
Okay, if there are no further submissions, Honourable Senators, the question is that clause 18 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 18 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 18 as amended now stands part of the bill.
Clause 19.
Honourable Senators, the question is that clause 19 stand part of the bill. Attorney General.
Yes, sir. Be amended as circulated at page 6. Mr. Vice President, we are proposing to insert after the notice under section 18 in A Roman 2 the words "or pursuant to any other written law," so that we can contemplate where warrants may be issued under other law for this type and category of data, communications data or stored data. Those are things which other laws currently contemplate can be obtained by way of warrant. For example, the Preliminary Inquiries Act, the Administration of Justice Indictable Proceedings Act, and the Proceeds of Crime Act.
Senator Diana.
Thank you, Mr. Chair. A point of clarification as well. Subsection 9, I believe it is.
Yes.
Right. Which speaks to the public interest immunity application. Now, I'm just seeking some clarification in the sense that how, in the event that a conversation is intercepted and a third party information is being discovered by a third party, which indicates that it may be a threat to public interest or national security. Is there a time frame in which this application for the public interest immunity would be submitted, and should it be stated in the law?
Okay. So the public interest immunity is a very careful term of art in law, and it is the immunity granted to the prosecution not to disclose something. So subclause 9 that we're adding into section 20. Section 20 is where you are obliged to destroy, right? So section 20 of the Parent Act is where you have a positive obligation upon the people that have intercepted or received warranted information, either by way of warrant or non-warrant, to destroy information which is not relevant to the process immediately. And then there's safeguards for destruction. In fact, we took a lot of time to put that into the regulations, which will be laid in this House in a matter of days. What this is here is an exception to the rule for disclosure to the defense. So information which may reveal the commission of other offenses by other people, i.e. not the accused, or which may jeopardize other inquiries, shall not be disclosed to the accused, but shall be retained and be subject of a public interest immunity application to the court by the prosecution. So we're putting the prosecutor on a positive obligation statutorily, which exists in the common law in any event. We're now putting it in statute to say, you can apply to the court for the court to consider why you should not disclose this information, because it might prejudice some other inquiry that's going on, or the commission of an offense somewhere else, you let the court consider, under the public interest immunity provision, why you should not disclose that. Because the rules of disclosure in criminal proceedings oblige the prosecutor to disclose the worst version of his case, effectively put. And this is the reason to say why you should not disclose everything to the accused. It's not the prosecutor's decision, the court must consider it.
Then, point of clarification again. It says here that it shall not be disclosed to the accused, but shall be retained.
Yes.
How long would it be retained for?
Because there is no statutory limit for crimes, it could be retained indefinitely. But in these circumstances, the court would be aware of the process, and therefore some degree of judicial supervision is in there. In any event, under the Interception of Communication Act, there are annual reports, and when you see the regulations that are coming for the first time, I mean, we've had the Interception of Communications Act for quite some time right now, and we've had the SSA Act, which allows the SSA to do interception, since 1995. We've actually laid the regulations for the SSA Act. They're on this. They came in February. They were laid on this. They were published by legal notice in February. So we have the regs for that for the first time since 1995, and we're bringing this in. But because there's no statutory period of limitation for the commission of an offense, and the state can act at any point in time, that really is potentially as far as indefinite.
Okay.
Senator Vera.
And just, Senator Dunerein, when the prosecution makes a claim for public interest immunity, it's still for the judge to decide whether it should be upheld or not. So the court does have a supervising function.
Thank you, Senator.
Okay, no further submissions. Honourable Senators, the question is that Clause 19 be amended as circulated. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that Clause 19, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 19, as amended, now stands part of the bill.
Clause 20.
Honourable Senators, the question is that Clause 20 stand part of the bill. Honourable Senators, the question is that Clause 20 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 20 now stands part of the bill.
Clause 21.
Honourable Senators, the question is that Clause 21 stand part of the bill. Attorney General.
Mr. Vice President, we propose an amendment to Clause 21, which is to make sure that we have this tight. In Clause 21, which amends Section 23, we're deleting the word criminal. What we wanted to do was to broaden that and substitute in subsection 6 by inserting the words Section 8 or 11, after the word Section 8 or 11, or pursuant to a warrant under any other written law. It's in keeping with what we have done to preserve the warranting approach, Proceeds of Crime Act, Preliminary Inquiries Act, Administration of Justice Act, and any other law that may come forward. So it is for consistency with the previous amendments that we've adopted.
Okay, there's no further additions. Honourable Senators, the question is that Clause 21 be amended as circulated. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that Clause 21 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 21 as amended now stands part of the bill.
Clauses 22 to 26.
Honourable Senators, the question is that Clauses 22 to 26 stand part of the bill. Honourable Senators, the question is that Clauses 22 to 26 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 22 to 26 now stands part of the bill. Honourable Senators, we shall now move on to the new clauses as proposed in the circulated amendments.
New clause 12A.
Honorable Senators, the question is that new clause 12A be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 12A will now be read a second time.
New clause 12A.
Honorable Senators, the question is that new clause 12A be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 12A now stands part of the bill. Right. Back to this. Honorable Senators, the question is that clause 12A stand part of the bill. Attorney General.
Mr. Vice President, thank you. In preparing this bill, we omitted to include the confidentiality protection for stored communication and stored data in the same way that it has been done for intercepted communication, and therefore, as a ground for safeguard protection for the rights of all persons involved there, we wanted to add the confidentiality provisions to cover stored communication and stored data. But very importantly, what we're doing as well is that we're applying that across the board under any other law. It could be under proceeds of crime, preliminary inquiries, administration of justice. We think it imperative that confidentiality apply. Right now, there's no protection in terms of express confidentiality for the Section 5 preliminary inquiries, warranted information, or the proceeds of crime information, and this is a huge step in preserving the rights of the accused and other persons intercepted.
Okay, if there are no further submissions, Honorable Senators, the question is that clause 12A now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 12A now stands part of the bill.
New clause 17A.
Honorable Senators, the question is that new clause 17A be read a second time. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. New clause 17A will now be read a second time.
New clause 17A.
Honorable Senators, the question is that new clause 17A be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 17A now stands part of the bill. Honorable Senators, the question is that clause 17A stand part of the bill. Attorney General.
Mr. Vice President, this is a critically important addition for covering what goes on in the existing law right now. As I've been saying all night long, you can get interceptions, you can get warrants for the production of material under the Preliminary Inquiries Act Section 5, under the Administration of Justice Indictable Proceedings Act under Section 5 when that becomes operational, and right now under Sections 32 and 33 of the Proceeds of Crime Act. And there is nothing which generally speaks to any other law which may produce administration interceptions in any other law which may be future. So what we wanted to do in this Interception of Communication Act was to put down an anchor. The anchor is the new Section 18A, which this new 17A proposes. And this provides specifically, you must have the confidentiality provisions in Section 14 apply. You must have the assistance provisions in Section 13 apply. You must have the entity being served with the warrant associated not disclosing, etc. You must have the disclosure being permitted in certain circumstances, which subsection 4 allows. The permission to disclose to your attorney at law in subsection 5. The position of a constable not to disclose other than to certain persons in subsection 6. And the commissioner of police not disclosing other than to certain persons in subsection 7. And then the creation of an offense in subsection 8. Right now, what's happening under the Proceeds of Crime Act, notwithstanding Section 51 of the Proceeds Crime Act, which prohibits tipping off, There's no criminalization for breach of this kind of information. So this is very targeted at ensuring that there is tight management of intercepted material, particularly stored communication, where your phone may be in the possession of the police and they just basically rip it up, pull the information, and then you find it on the internet. That's a huge lacuna in the law right now. This section solves that and criminalizes police, even up to the Commissioner of Police, for improper disclosures, because we must maintain the rights of the individual in a careful way. So this is a tremendously important provision to better the laws of Trinidad and Tobago, which does not find itself in feature in law right now.
Okay, if there are no further submissions, Honourable Senators, the question is that Clause 17A now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 17A now stands part of the bill.
New clause 27.
Honourable Senators, the question is that new Clause 27 be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New Clause 27 will now be read a second time.
New clause 27.
Honourable Senators, the question is that new Clause 27 be added to the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New Clause 27 now stands part of the bill. Honourable Senators, the question is that Clause 27 stand part of the bill. Attorney General.
Mr. Vice President, it's good enough to have the new 17A. It's good enough to have the new 18A, forgive me, where we put in the general safeguards in the Parent Act, the Interception of Communications Act. But as a matter of law, we need to go to the Proceeds of Crime Act, we need to go to the Preliminary Inquiry Act, and we need to go to the Administration of Justice Indictable Proceedings Act and put the same safeguards in those laws so that it adds for ease of reading and judicial interpretation in those individual pieces of law. So new Clause 27 is the first one. It is to replicate the provisions for confidentiality, assistance, limited disclosure, and offences in the circumstance of the Proceeds of Crime Act.
Okay, if there are no further submissions, Honourable Senators, the question is that Clause 27 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 27 now stands part of the bill.
New clause 28.
Honourable Senators, the question is that new Clause 28 be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New Clause 28 will now be read a second time.
New clause 28.
Honourable Senators, the question is that new Clause 28 be added to the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New Clause 28 now stands part of the bill. Honourable Senators, the question is that Clause 28 stand part of the bill. Attorney General.
Mr. Vice President, I adopt all of the submissions for new Clause 27 and apply them to new Clause 28. We're doing exactly what we did there, this time for the Indictable Offences Preliminary Inquiry Act. This is the act where we put in confidentiality, assistance, limited disclosure, and offences. In that parent law, it's effectively a consequential amendment across.
Okay, if there are no further submission, Senator Sipasad.
Mr. Vice President, through you to the Attorney General, in my presentation in February, I raised the issue of a sunset clause given the nature of this bill, but you didn't address it in your wrap-up. And it's something I really would like you to tell me whether you agree or disagree, but give me some answers to how we proceed.
So, insofar as what we're effectively adding to the safeguards that didn't exist in the original law, which had no sunset clause, and which has been in existence for 10 years, I apologize, I omitted to mention this in my wrap-up. It was the gap between February and March that caused that. But number one, the December law 2010 brought this law into effect. It's now been on the books of Trinidad and Tobago for nearly 10 years. There was no sunset clause. Number two, because what we're doing today is really adding constitutionality to the bill that didn't exist before, I would think it somewhat difficult to put a sunset clause on constitutional savings. If it were the original law, well, then that would be different. But now we've seen the test of time that we didn't need a sunset clause for the original law. So to put the soothing balm and the savings for constitutionality on a time clock, a limited time clock, I think it would not be in our best interest to erode that aspect.
And you're comfortable with that?
Oh, most definitely. Why would I want to limit a benefit as opposed to a constitutional benefit? Without this amendment today, somebody could actually go to court right now and challenge this law and strike it all out. So I wouldn't want to put that on a time clock and then have that subjected to difficulties.
Thank you.
Okay. If there are no further submissions, Honourable Senators, the question is that Clause 28 now stand part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 28 now stands part of the bill.
The preamble.
29.
New clause 29.
President, if I may, I had indicated earlier, it's not in your circulated amendments. I had indicated earlier there were a few tweaks to the circulated amendment. We dealt with that to Clause 4A. This is the other one now, and this is to add a new Clause 29. In the earlier 4A, I alerted to the fact that we had not proposed, because we had omitted, to amend the Administration of Justice Indictable Proceedings Act. If I could explain that to the...
AG, before you go into the explanation, we do have, have to add the clause to the bill first.
But because it's not circulated, I need to explain it.
Right, so we're going to add the clause to the bill, and there's a part where you will be able to explain it once we get to that section.
Okay, I apologize.
Honourable Senators, the question is that new clause 29 be read a second time. Those in favour say aye. Aye. Those against say no. Say again? He's going to explain the new clause 29. So he's making the amendment on the floor. That's what he's doing. But before he can do that, it's not part of the bill right now. So I have to add it to the bill first, which is the procedure that I'm following. So I'll start again. Honourable Senators, the question is that new clause 29 be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New clause 29 will now be read a second time.
New clause 29.
And the wording of that, Mr. Vice President, the wording will be as follows. The marginal note will be Act number 20 of 2011, amended, 29, with the following words. The administration of justice, open brackets, indictable proceedings, close brackets, Act is amended by inserting after Section 5 the following new section, colon. Open brackets, non-disclosure as a marginal note, and then it will be 5A. And Mr. Vice President, the wording will be an exact replica of what we did for clauses 27 and 28. In other words, then, we'll be lifting exactly what is appearing at page 9, 10, and 11 of the circulated amendments, where there are subsections, where you see 5A, 1, 2, 3, 4, 5, 6, 7, 8. That's the exact wording. The only thing that would be different is the chapter number. Sorry, that actually stays the same. That actually stays the same. So, Mr. Vice President, hold on. If I could give you what the wording of Section 29 will be, if you were to use the following template to do it. Are you with me? Sure. through you, Mr. Vice President, to all honorable members, if you'd look to the draft that is circulated as an amendment, if you just look at page 9, everybody's with me? At clause 28, this is the new clause 28, the wording for clause 29, the new clause 29 will be as follows. At the marginal note where you see chapter 1201 amended, you're going to instead put Act number 20 of 2011 amended. Then, where you see the number 28, it'll be 29. Then, the words, the Indictable Offences Preliminary Inquiry Act, you would change that to the Administration of Justice, open brackets, Indictable Proceedings, close brackets, Act. And then everything else is exactly the same. So that's the wording of the new clause 29, and it is to capture the same safeguards that we did for the Proceeds of Crime Act and the Preliminary Inquiries Act. Are you with me, Mr. Vice President?
I'm with you.
Just suggesting that if the Attorney General could have circulated this thing, because, I mean, you say everybody is at a disadvantage.
I don't understand what the Attorney General just said.
What I'm saying is that I would prefer to see something before me. This is a very important matter.
That is understandable. Yeah. Unfortunately, it's not possible.
Cabildo Chambers is far away from here.
No, not only that, we have in the past and in other bills that we've done had some amendments put on the floor. Maybe they were left out or just basic discussion. I have accepted new clause 29 specifically because this particular situation is similar to that. That's why I've allowed the Attorney General to explain in great depth exactly what that clause is going to look like. And what he has indicated is that in terms of the formula and what is being used, it is the exact same, as a matter of fact, as 27 and 28, except what he has called out by way of the chapeau and the marginal note. If everybody understands that, then we can move forward with clause 29 in this manner. The procedure is correct in that sense. You okay with that, Senator Mark?
I don't understand that, sir. But if you are happy, sir, that's your choice.
Okay. The question is that new clause 29 be added to the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. New clause 29 now stands part of the bill. I'll read it out again, just for the benefit of members. Understandably so. Honorable Senators, the question is that Clause 29 stand part of the bill. Clause 29 will read, Act number 20 of 2011, and the marginal note, the Administration of Justice, open brackets, Indictable Proceedings, close bracket, Act. And
this is imaginary.
Yeah.
This is amended by after Act.
Yeah.
Is amended.
Right, and it's further amended by, no, it's amended by inserting after section 5, the following new section. Yes, as appears on pages
9, 10, and 11.
10 and 11.
In exact word form.
In exact word form from 5A.
As circulated.
As circulated. Everybody follow?
Yeah.
Mr. Chairman, that's very confusing to me.
Mr. Vice Chair, could I assist? So, new clause 29, which proposes an insertion into the bill, will read as follows. And it is in the following words. If you would turn to page 9 of the amendments that have been circulated. If you're with me, Senator Richards? Okay. Where the marginal note says Chapter 1201 amended, it'll read Act number 20 of 2011 amended. Where the number 28 appears, it'll read 29. Where the words Indictable Offences Preliminary Inquiry Act are, you'd strike that out, and instead you'd put the Administration of Justice Indictable Proceedings Act. And then the exact wording from the word is at the chapeau there, straight down page 9, straight down page 10, straight down to page 11, ending in subparagraph 8 with the full stop after Interception of Communications Act. That's the exact wording for the new clause 29.
Okay.
Yep.
Right.
Because what this does is that there are 3 laws that permit warrants to obtain stored data or communications data. The laws are the Preliminary Inquiries Act. We did that in new clause 27. The second law is the Proceeds of Crime Act. Sorry, the first one is the Proceeds of Crime Act. We did that in new clause 27. The second one is the Indictable Offences Preliminary Inquiries Act. We did that in clause 28. And the third one is the Administration of Justice Indictable Proceedings Act. That's the law that's going to repeal and replace the Preliminary Inquiries Act. So we wanted to capture that law at the same time. And it's also a new section 5A. So that's the wording for it in perfect word form as just described.
Thank you.
Everybody's good? Okay, so just for procedure, I'll repeat that. Honorable Senators, the question is that Clause 29 stand part of the bill as follows. In the marginal note, Act number 20 of 2011, amended. Also to say the Administration of Justice, open brackets, Indictable Proceedings, close bracket, Act, is amended by inserting after Section 5 the following, and if you look on page 9, the following new section, if you look on page 9 all the way to page 11, starting at 5A and ending at subparagraph 8, copied exactly. Honorable Senators, the question is that Clause 29 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 29 now stand parts of the bill.
The preamble.
Honorable Senators, the question is that the preamble to the bill be approved. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The preamble to the bill is approved. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Is yours? I have mine. So, do the reading untitled. Attorney General.
Mr. Vice President, I wish to report that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Attorney General.
Mr. Vice President, I beg to move that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it.
A bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508.
Honourable Senators, this bill requires a special majority. The clerk will now conduct a division.
Mrs. Paula Gopiskun.
Aye.
Mrs. Batiste Primus.
Yes.
Mr. Ambrad. Yes. Mr. Senalan.
Yes.
Mr. Moses.
Yes.
Mr. Hussain. Yes. Ms. West.
Yes.
Ms. Cox.
Yes.
Mr. Singh.
Yes.
Mr. Cummings.
Yes.
Dr. Henry.
Yes.
Mr. Duque.
Yes.
Mr. Thomas.
Yes.
Mr. Young.
Yes.
Mr. Mark.
No.
Mr. Mean.
No.
Mr. Hussain.
No.
Mr. Bika.
No.
Mr. Sobas.
No.
Mr. Sturge.
No.
Mr. Richards.
Aye.
Ms. Schott.
Abstain.
Mr. Vera.
Yes.
Dr. Dial Singh.
Yes.
Ms. Dionaran.
Yes.
Ms. Sipasan.
Yes.
Mr. Timal.
Yes.
Mrs. Thompson Aye.
Yes.
Dr. Delaremi.
Yes.
Mr. Vice President, with a division of 22 members voting for, 6 members voting against, and 1 abstention.
Honourable Senators, the results of the division are as follows: 22 for, 6 against, and 1 abstention. The bill is passed. Acting Leader of Government Business.
Mr. Vice President, I beg to move that this Senate do now adjourn to Tuesday, March 10th, 2020 at 1:30 p.m. Mr. Vice President, on that day we propose to deal with the Trinidad and Tobago Revenue Authority bill. Thank you.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised on the motion for the adjournment of the...
Mr. Vice President, as far as I understand, the Revenue Authority bill is in the other place and awaiting a decision. That is in the other place. So I can't see how a bill could just come from the other place up here for debate. I don't know how it arrived there. All I'm telling you, Mr. Vice President, that bill is in the House of Representatives waiting at their vote. So I don't know how it arrived there. No.
So, Senator Mark, if you take a look at the order paper if you take a look at the order paper that all senators have before them at item 15, public business, government business, you would see at position 5, 6, 7, 8 a bill entitled an act to establish the Trinidad and Tobago Revenue Authority and for related matters by the Minister of Finance. Sorry.
Let's be serious now. This is not a Mickey Mouse arrangement, you know. This is a parliament. In the House of Representatives, there's a report that is to be debated and a vote taken. So you can't come with some...
So Senator Mark,
Yes.
in relation to what I just said and the fact that the bill is on the order paper, this bill was introduced at the sitting of the Senate held on Tuesday, November the 26th, 2019. Okay? Acting Leader of Government Business, could you please just do the procedure once again?
Mr. Vice President, I beg to move that the Senate do now adjourn to Tuesday, March 10th, 2020 at 1:30 p.m. And on that day, we propose to take the Trinidad and Tobago Revenue Authority bill to the next stage.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment of the Senate. Senator Sipasad.
Thank you, Mr. Vice President. I wish to raise the following matter on the adjournment: the need for the government to immediately address the long waiting period for and delivery of new and renewed Trinidad and Tobago passports. Earlier this year, the unacceptable delay in processing the application and issuance of passports by the Immigration Department was widely reported in the media. The editorial in the Trinidad Express newspapers of February 16, 2020, stated in part that it defies logic how a public service as critical as passport processing should have fallen into such sustained crisis without any attempt by the government to address the problem. The government, in the persona of the Minister of National Security, visited the passport offices and decreed that the time from application to delivery should be reduced from 5 or 6 months to 1 month. This action alone is not adequate to ensure that the service will immediately and automatically improve by at least 80%. This is all well and good, and to generalize, Mr. Vice President, you are already familiar with the many complaints from diverse sources about the poor quality of customer service which the general public must endure for most of the offices of the public service. Mr. Vice President, it is widely known that not too long in the past, the efficiency by the Passport Processing Department was professional and passable. To revert to such a level of service cannot be done in an autocratic manner. Strong and effective leadership, as well as modern digital process engineering techniques, must be deployed to achieve lasting change for the better. It is not an overnight event. Today, however, I'd like to speak specifically about the length of time it takes citizens to obtain or renew their passports. The current wait time is a drastic decline from a few years ago when a Trinidad and Tobago passport was processed in 2 weeks. The situation is even worse for foreigners applying for residence based on marriage and other grounds.
All right. Just allow Senator Sipasad to move her motion on the adjournment. If you all would like to speak to each other, I invite you to step behind the chamber, the chair, to have your conversation. Continue, Senator Sipasad.
I cannot understand how the significant improvements made in what was a notoriously inefficient service have been allowed to fall into such a state of crisis. Based on my research and notwithstanding the appointment process presently, it takes about 2 months to get an appointment and a further 1 to 2 months to receive a new or renewed passport. As a result, many people renewing passports select the expedited option at an additional cost of $300. In my view, this is like extortion. Citizens' expectations must be to pay the regular fee of $250 for efficient service. Another wrinkle in the system is citizens are forced to scout the various passport offices in search of better turnaround times. The Tobago office is one such option, with all the related additional costs for travel and accommodation. The fact is, Mr. Vice President, comparatively speaking, passport processing in Trinidad and Tobago is more tedious than in any other English-speaking CARICOM country. The wait time for passports in some CARICOM countries are as follows: Antigua and Barbuda, 3 weeks to 1 month; Bahamas, 5 to 10 days, no appointment; Dominica, 3 weeks, no appointment; Grenada, 3 days, no appointment; Guyana, 5 working days; Jamaica, 7 days, no appointment required. They also have an expedited option of same day, next day, and 3 days at the Passport Department's head office. St. Vincent and the Grenadines, 7 working days, no appointment required. Barbados, 10 business days, appointments are available within a week. Mr. Vice President, this malaise and inefficiency has real costs. In many businesses, the time value of money is vital to their survival. Also, citizens who need to travel for business, education, or medical treatment must face this ineptitude in order to obtain their passports. Without being overly dramatic, lives and businesses are at stake. And this administration must care and must act decisively to delve into the root causes and find and deploy lasting solutions to the benefit of all. I therefore ask, through you, Mr. Vice President, that the Minister of National Security not only amplify the reasons for the inordinate delays, but to provide the Senate in a timely manner a policy and strategy document for the type of clinical and professional service from the Immigration Passport Department which must be available to all citizens. Thank you, Mr. Vice President.
Minister of Foreign and CARICOM Affairs.
Thank you, Mr. Vice President. As a caring and responsible government, we strive to meet the tenable needs of our population. Whatever the pathway that leads us to such needs, we endeavor to treat with them in a compassionate and responsible manner. As regards the concerns raised about the backlog in passport delivery, a decision was taken to increase the production hours by calling out additional staff to the passport production system. We continue to persevere in marshalling the required resources to address this matter. As of today's date, first-time passport applications, which were received towards the end of January, are now being processed. Passports in favor of these applicants are ready to be issued in short order. Applications for renewal of machine-readable passports are now being processed in a period of 1 month or even less time. We anticipate that this delivery time will be sustained in the short term and further reduced until the objective of 1 month delivery time across the board is achieved. Allow me to thank you, Mr. Vice President.
Senator Vera.
Thank you, Mr. Vice President. Mr. Vice President, the matter I wish to raise on the motion of the adjournment is the need for the government to appropriately address the persistent presence and continuous increase in the number of street dwellers and the threat they pose to themselves, the public, and to public property. Mr. Vice President, I have been noticing of late an increase in the number of vagrants around Port of Spain. Now, I don't know what obtains in other parts of the country. This is not a new problem, but it may be getting worse in the face of ever-increasing job losses, the cost of living getting higher, and the stresses and strains of life today. My dictionary defines vagrant as a wanderer who has no established residence or visible means of support. I don't know what the government has in place towards addressing the issue, but it seems to me there should be a policy to prevent vagrancy. Some weekends ago, I saw a very tall vagrant walking around Newtown, stark naked. He was approaching people in cars and he was asking them for money. And not long after that, I saw another vagrant relieving his bowels in the Augustus Williams Square in Woodbrook. Children were nearby in the playground. Vagrants are sleeping in public places. They soil and spoil the covered waiting areas for buses. Some even damage and interfere with property. In my neighborhood, there is a problem every time a certain individual is released from prison. It's a cycle that's been going on for years now. He's regarded as a pest, but he's a human being and he's homeless. This is not a problem neighborhoods can easily solve. It would be wrong to physically harm him if he's caught trespassing or stealing. But if he's fed and if he's offered sheltered, there's a concern that more vagrants might come, or that he will betray the trust of the Good Samaritans in the neighborhood who want to help him. So what's to be done? Vagrants are citizens, and the government is responsible for all citizens. It is shameful to ignore the problem. Now, it's easy to turn a blind eye and to stereotype vagrants as lazy or crazy, but there are multiple reasons for vagrancy. Mental illness, drug addiction, breakdown of family and community support, insecure work, job losses, or just poverty. The point is, every vagrant has his or her own unique set of circumstances and may require help of a different nature. The problem is further exacerbated by the fact that many reject help, seeing intervention as an imposition on their freedom. I used to help a deportee from the United States who eventually died of AIDS. I would give him food, sometimes shelter, occasional work, clothes. But he would refuse to stay in any shelter, preferring to live in a cemetery. Now, this poses a real difficulty for outreach groups like Living Waters, Salvation Army, St. Vincent de Paul. So what to do? Vagrants, should they be put on an island like Carrera, where they can opt to either be in the shelter or to sleep under the stars as they see fit? Are there sufficient shelters in the country? Are the shelters up to speed? There should be shelters for the aged and elderly, for those who are unable to find work or have no financial means, for those who lack basic accommodation. Perhaps the poorhouse or something like that may be in need of resurrection. The issue is empathy and respect. Do we treat vagrants as lesser beings, or do we care for them as fellow citizens, treating them humanely? Should the solution be a mix of providing care for them on the one hand and protecting the public from them on the other? Is this a matter of benevolence or one of national pragmatism? Is legislation necessary? Is vagrancy regarded as a problem by the authorities? And if so, is there an agenda for reform? Can government indicate whether the problem is being addressed and solutions towards effective resolution? I thank you.
Acting Leader of Government Business.
Thank you, Mr. Vice President. I thank Senator Vieira for raising this very important issue. I want to make 2 points as I open. That is to say that between 2017 and 2019, there was a 6.5% increase in the number of street dwellers, as the motion refers to the persons who are found on the street. So in raw terms, the number increased from 414 in 2017 to 441. Second point I want to make from the outset is that, as Senator Vieira has pointed out, the experience so far has shown that about 30% of the street dwelling population suffer from some form of mental illness. Now, I could tell you as the minister responsible for the Queen's Park Savannah that we contend with them often. The presence of street dwellers in the savannah fluctuates. Sometimes it's because they are moving from somewhere else and they have temporary shelter in the savannah. And my own experience has been that they range from perfectly normal persons with jobs who appear to be completely homeless to those who are mentally ill, and at least one case, one who is extremely violent. So the issue of street dwelling, the experience of the Ministry of Social Development and Family Services is that the issue requires an integrative and collaborative approach comprising interventions not only from government ministries, as you correctly pointed out, but from civil society, including the private sector and NGOs like Living Waters. The ministry is closely collaborating with the Ministry of Health in relation to mental health issues and the Ministry of National Security in relation to national security issues. And I would provide some detail in relation to the involvement of the police and the Attorney General in relation to law reform. The strategy is really based on 4 elements. The first is prevention, and provisions are made under the community care program of the ministry to prevent socially displaced persons in various hospitals from moving to the streets. In fact, some years ago, you may recall, in the San Fernando General Hospital, it was discovered that you had people living in the hospitals, some of whom were patients who, upon discharge, never left the hospital, and some of them who were never patients but found their way in the hospital. So the community care program is designed to reduce the occurrence of persons who are socially displaced living in the hospitals, or persons who are in the hospitals moving onto the streets. To deal with that aspect of the prevention, the ministry has engaged several privately operated homes across the country to provide care and accommodation to persons who have nowhere to call home. At present, there are 101 persons in homes under the community care program, and some persons are waiting to be placed. The second element in relation to prevention is that the ministry provides assistance under the rental assistance program managed by the Social Welfare Division to households which are facing eviction, as well as those that are at risk due to natural or man-made disasters. Thirdly, recognizing the need to facilitate collaboration of key government agencies to address the issues, the ministry continues to work through a working committee with various NGOs and various entities which have under their ownership or control shelters. In fact, the ministry currently provides a monthly subvention to 3 shelters, and other ministries such as the Office of the Prime Minister have established new facilities to target vulnerable groups who are likely to become street dwellers unless there's some form of intervention. To support the prevention, there's an ongoing exercise of data collection, and it is as a result of the most recent exercise in October 2019, I was able to provide you with that information on the current number, which is 441 persons now. The accuracy of the count was done over a 2-day period in October, and of course, it all depends on the people being, as I say, they move, and the count was done in areas such as Port of Spain, San Fernando, and Arima. The second approach of the Ministry of Family Services and Social Development relates to the voluntary engagement of street dwellers through field officers in an effort to move them off the streets and move them into different types of facilities where they could have places to live and long-term care. Recognizing this percentage, 30% being persons having some form of mental illness, the ministry has had to re-engage the Trinidad and Tobago Police Service in what was known as the move along strategy to get them off the streets and into places where they could be cared for. In the case of the people who are suffering from some form of mental illness, they would have to be removed involuntarily. The Police Service under the Summary Offences Act 1921, the Police Service Act 2006, and Mental Health Act of 1975 has the legislative authority to involuntarily remove persons from the street. The Ministry is also presently working with the Office of the Attorney General to address other legislative issues, which include the finalization of a policy for the proclamation of Act number 59 of 2000, which is the Socially Displaced Persons Act. Thirdly, in relation to accommodation for street dwellers, the Ministry has made significant investments to ensure that provisions are made for the care and well-being of this population. The Ministry provides 2 NGOs with subvention for the operation of shelters, that is the Center for Socially Displaced Persons in Port of Spain, operated by the St. Vincent de Paul Society, and the CSDP in San Fernando, operated by Court Shamrock. And my colleague, Minister Hussein, former mayor of San Fernando, has had a lot of experience with Court Shamrock. In fact, he introduced some hair cutting and other services to the persons who use that facility. The Port of Spain location has capacity of 200, and the center in San Fernando has the capacity to accommodate 78 persons. In addition, a subvention is paid to Nazareth House to provide accommodation and other support services, particularly to the mentally ill, socially displaced persons who require help. The next area that the Ministry operates in is in relation to assessment, and the Ministry continuously, with the support of other agencies, including the British High Commission, provides assessment services to identify the continuing risks of persons ending up becoming street dwellers. And finally, the area of rehabilitation and reintegration. The Ministry works with the Ministry of Health and other facilities, including the New Horizon Facility, a rehabilitation center for homeless persons, which was handed over to the Ministry of Health in October 2019. The Ministry operates the Piparo Empowerment Center, and that is a center that was famously acquired through the handling of the estate of Mr. Dolcedi, and therapeutic community. It's a therapeutic community established for persons who are substance abusers. Mr. Vice President, this issue of homelessness and street dwelling, mentally ill, and persons who sometimes roam the street. I've seen the naked man. He has an incredible physique, but he should be fully clothed and put in a place where he could be cared for and taken care of. It is something that used to be prevalent in the city in the days of Rambo and some other extremely muscular men who refuse to put on clothes, but it is something that cities around the world grapple with as people face the high cost of living, the stresses of life, the pervasiveness of mental illness, and the Ministry of Social Development and Family Services continues to grapple with these issues while making sure that the government has the appropriate policies to deal with it. Senator Vera, I thank you very much for raising this motion. We would not ordinarily have an opportunity in this House to share information on what is happening with our street dwellers, and I thank you very much.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, March 10th, 2020 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, March 10th, 2020 at 1:30 p.m.